Thank you so much, Robin, Professor Algamel. Now we are going to turn to our international panel to talk about the developments in the international sphere, and we have some very interesting panelists here today. It's going to be moderated by Maria Strong, and we are going to have Michelle Woods, who is at WIPO and also an alum from here, and Dr. Till, who's going to also join us. We've heard earlier that she is the newly appointed Director of AI, and I believe we are also going to have Ros Lynch, who is the head of the UK IPO, to talk about this. So they're going to talk about all of the different issues that are arising in the world and in their countries. Thank you very much.
All right, thank you, everybody, as we're getting settled here. Again, we want to welcome everyone. And as the Director General said, this is a question that is facing all national governments, but it's also a global issue. And so this is a panel where the international gets to meet the domestic. And so the way we're going to do this is I'd first like to start off with the national experience that Dr. Ros Lynch, who is the Director of Copyright and IP Enforcement at the UK Intellectual Property Office. She will be discussing some of the challenges she has experienced in her country, and she had the benefit of working with WIPO last summer also on preparing a two-day presentation on AI. Then we'll go to, after that, we'll go to Dr. Ulrike Till, who's new to WIPO. I think, you know, your first month maybe of work. So she'll be able to discuss some of the work of her new division. And then we'll turn to Michelle Woods, who can also talk about additional WIPO initiatives at the international level. And we hope to have time to have some Q&A between the panelists on some of the issues that are pressing. So with that, Dr. Lynch.
Good morning, ladies and gentlemen, and thank you, Maria, for correcting my job title. Whilst I would like to be the head of the UK Intellectual Property Office, I am not. I'm only responsible for copyright and IP enforcement, but I've also taken on the responsibility as the senior responsible officer for everything we do on AI. So I'm really very grateful for this opportunity to be here just to share with you some of the things that we've been thinking about and doing within the UK. For the UK, the government has set AI as a priority, and it set an ambition to make the UK a global centre for AI and data-driven innovation. And in the Intellectual Property Office, we've been thinking for the past year about what our role is in relation to helping the government deliver on that ambition. And we've been working on basically in two streams. So we've been doing quite a bit of operational work, looking at the use of AI in terms of trademarks and patent registration. But that's not what I'm going to focus on, because we feel that the most challenging, the most interesting bits of the AI field to fix on is the big questions around the policy, around what happens in terms of trademarks, copyright, etc., policy and legislation. And that was why in June last year we held an international conference to look, also in cooperation with WIPO, to explore the economic, commercial and legal implications of AI for IP. We didn't focus exclusively on copyright, but covered all the rights. But it became very clear from the 2 days of discussion that some of the biggest challenges posed by AI lie with the copyright framework. And I think Director Gurry already posed some of those questions to you. And, you know, he mentioned authorship, and I think it's come up in every conversation so far. And we do actually feel and agree that AI is actually challenging some of the very settled notions of what authorship is, and it's calling into question probably the very foundation on which copyright is based, which is human authorship. We in the UK thought, that we could answer some of these questions around who is the author, whether or not there is an author involved, and who would that author be if an AI produce works in art, you know, whether it's art, music, etc. And especially if there's very little human input into that work. So we have in UK law a computer-generated works provision, which is not something that you find in many other countries around the world. I think there are only about 3 other countries or so that have such a provision. And in our provision, computer-generated works are defined as works generated by computer in circumstances where there is no human author. This was proposed in 1987, and the provision, if reading I certainly wasn't in the IP office then, but reading the debates around it, it said that the provision was specifically included to deal with the advent of artificial intelligence. I was quite shocked that the UK Parliament was actually thinking about AI, but at that stage. But in my mind, what we know of AI now, I don't think that they could have conceived of where the technology would have gone and what it would be capable of doing now, let alone what it would be capable of doing in 20 years' time. For our provision, computer-generated works provision, the author is the person who made the necessary arrangements for the creation of the work. So this could be the operator of the AI, it could be the computer programmer who wrote the algorithm, whatever. It has never really been defined. It's just been left as the person who made the necessary arrangements. Protection of these works lasts for 50 years from the date the work was made. So it has quite a long period of protection within our law. However, there's a huge tension for us between the concept of computer-generated works as defined in law and the concept of originality. To be protected, computer-generated works must be original. The law appears to assume that originality is a human quality only. So in the UK and in Europe, an original work is one which is the author's own intellectual creation. The concept has been further developed by the courts, and considerations include whether the author has made free and creative choices or reflected their own personal touch. So it's very, very human defined. And for us, it's not immediately obvious how current AI-generated works could fit with this definition. And the tension makes it unclear to us how a work that is generated without a human author can actually be protected under the computer-generated provision within our law. So we've got something in law, but actually we don't know what it means, and we don't know how we could use it in this context. So that's, for us, an added headache because, we thought we were being very forward-thinking, 20 plus years ago, but actually it's just complicated the situation even more. So looking beyond the specifics of UK law, I just want to touch on a few other things. And this is something which has already been raised. There's an interesting global debate to be had around the role of copyright protection as an economic incentive when it comes to AI-generated works. So copyright is generally considered somewhere between an economic tool that incentivizes and rewards creativity, but also a natural right of authors to protect the creative works as expressions of their own personalities. There is a question then around whether AI development needs incentives, and I think that this was just raised. And if so, what is the best vehicle to achieve this? Is copyright protection a necessary incentive? Could there be another mechanism? And again, I know that Rob just raised that. Does AI actually need incentivizing? We seem to be having, from what we've heard, AI is being used in so many contexts. More and more works are being produced every day. It's being used across the economy. So is it doing okay, or do we actually need to do something to actually incentivize more creative works? We've been asked, do we need a new right? Which is something we have to consider. We've also been asked to look at our exceptions to copyright, and should we have an exception for works created by AI? But also, what is the role for licensing in this space? These are all questions which we are still trying to come up with answers to. If it does make economic sense to protect AI-generated works, we need to ask when the copyright should subsist, so what type of works would qualify for the copyright protection, who should own the copyright, which we've had some of those conversations already this morning, and then how long, which again I think Director Gurry alluded to. The speed at which an AI can create creative works, whatever they are, whether they be music or paintings, etc., just doesn't feel like 50 years is the right length of time to give it, because these works are constantly coming out, they're being adapted. So we do need to have a conversation about, if we're going to protect AI works, for how long do we need to protect them? And I appreciate what Director Gurry said earlier about the length of time it takes to agree anything globally, but I do feel that we need to have a global conversation, and we do need to have some kind of global standards or whatever in this space. I'm not talking about a big treaty, but we do need to have some kind of agreement, some kind of shared understanding of not just what the problems are, certainly how to define it, and what we need to do in this space. I also want to just briefly touch on infringement and liability. I know there are huge questions around whether or not the AI is making copies, is it keeping copies, where these copies are stored, if it has permission for some of the data that's being fed in, who gave permission for that data to be used. If so, if there is infringement happening, who is liable? Is there a case for also considering secondary infringement of copyright? Would that lie with the institution where the computer is based, or with the individual who wrote the algorithm, etc.? Those are all things which we need to consider. And my final point is one which is not normally talked about in relation to copyright, but I think it's incredibly important that we do not lose this from the discussion on the relationship between AI and copyright, and that is the ethical use of AI in this space, in the creative process. I do really think that this is hugely important, and it shouldn't just be left to the medical field or to something else. We need to actually look at the ethics of doing this within the creative space. So just to conclude, in the UK, we are still thinking about these questions, and we're still trying to work out answers to them. We are shortly going to launch our own call for views we're going to do it across all the rights, not just copyright, but we will be asking quite detailed questions, some of which I've mentioned, some have been mentioned earlier around data and competition, etc. And following that, we will be publishing a government response, giving answers to these questions where we have them. But we do recognize the importance, as I said earlier, of having a shared understanding of the issues, and I think also having consistency in some of our answers, even though we may have some kind of domestic flexibility. So we look forward to continue to work with WIPO and also with the US Copyright Office as we try to grapple with this. Thank you very much.
Thank you very much, Dr. Lynch. We too look forward to working with you as you grapple with, as you said, your nagging headache. I think that might be coming across the pond to us as well. And with that, I turn to Dr. Till.
Good morning. So I'm the director of the brand new AI policy division at WIPO. And today marks 3 weeks in role and 3 weeks for the new division. So in some ways, I feel like you should be standing up here and I should be sitting down there, because I certainly have more questions and no answers at all. When I was preparing for this talk, I was thinking, I've only been in this job for 3 weeks. What can I do to add value to the discussion? What I thought I would do is take you a little bit through the WIPO process, the conversation on AI and IP, and where I can, by my background, I come from private practice, I'm German qualified and UK qualified, give you a little bit of an international perspective, why some of these questions might have different answers or different perceptions in different countries, and also why I think having an international discussion and a wider discussion of all the issues is so crucially important, and that that feeds in why I think the WIPO conversation is so crucially important in raising awareness of different angles to the different questions. The growth of AI, I'm not telling you anything new, it's everywhere and expanding rapidly. I'm not sure how many of you have seen the WIPO Technology Trends Report that came out at the end of last year. It's not copyright, it's patents, but it looks at more than 130,000 patent applications. It's one of the first studies to analyze the trends. It's a big volume, but some of the things are fascinating in it all of them are. But what I took away is there's a real shift that you can see from theory to actual inventions. So there's patent application now rather than just publications. Machine learning is mentioned in more than a third of those applications. And really quite telling for me is it is across a whole range of industries. It's from agriculture to education, from transport to IT technology. So it really hinges home that it concerns all industries. It's a rapidly evolving field. I think I'm supposed to click. I forgot to click. With the field that is rapidly evolving, as we can tell even in the discussion today, is a multitude of discussions that are exploding. The discussions are on national level, certainly of governments. A lot of governments have AI strategy papers or policy in place. Not very many of those mention IP at the moment, but that discussion is certainly starting. There are fora here nationally where issues are raised in the UK, in the US. The patent offices around the world, the IP5 have got a cooperation to look at how they can use AI in the administration of IP, but also they've started amending the examining guidelines to deal with issues of AI. When you look into the academic papers and legal publications, as I've done over the last 3 weeks, it is overwhelming. There's so many of them, there's so many views and so many discussions. And the discussions, unsurprisingly, go across all IPRs. It's from copyright to trademarks to patents to confidentiality to rights of data. For me personally, where it comes down to the policy question is really, is the current IPR system fit for purpose? Does it fit the new AI world? Or does it need adjustments in order to strike a fair balance between protecting the investment into AI and the fostering of technology going forward and innovation? And that really, for me, is at the heart of all of the discussions. And really, this is where the WIPO conversation on AI and IP comes in. Having all of those discussion points, having all of those opinions, having the question asked and having them asked internationally in different forums is a fantastic way of helping us all understand the issues, not so much have the answers, but understand the issues that we ought to be looking at. WIPO is giving a forum to that. As you know, and many of you were part of the discussion before I even started, the conversation started in September last year in Geneva. It is at the point at the moment where WIPO has published a draft issues paper. It's on our website. If you haven't seen it, have a look on the website. It should get a little bit more intuitive going forward. We're changing that at the moment. The call for comments is until February 14th. At the moment, it simply is asking the question, have we got the questions right? Are the things we're thinking about the things you're thinking about? Do we need to change of that? Are they on the right emphasis? The idea is very much that we will, having received the comments of February 14th, revise the draft issue paper, and that will guide the agenda for the next conversation that will happen in Geneva on May 11 to 12, and a second conversation planned for the end of this year, Q3, Q4. One of the things that is quite close to my heart is, as I said, we're at the stage of asking the questions. are we getting the questions right? And getting the questions right for me is really important, and comes a little bit from my background. I spent very many years as a litigator, and I know what happens when systems get changed, and they get changed in unforeseeable ways. That always happens when you tweak systems, but I think the more time we actually spend having the discussion to get the questions right, the more we can minimize unforeseen consequences when the systems get changed. That is, of course, as the Director General also said, it's a race for AI. The field is moving very fast, and there is a tension between spending enough time on getting the questions right and seeking answers to those questions. Without giving anything away, a lot of the comments on the draft issue paper are racing ahead to trying to answer the issues, but my call at the moment is help us define the issues so we can better answer them when we continue the conversation. Coming to copyright, and really for me, when I was thinking about what I was going to say, copyright and AI falls into three buckets. There is, of course, the really important question on ownership, on authorship, the works created with AI. Does copyright apply? What are the implications of copyright? But I think copyright for me implicates every part of the AI creation system. When you think of the algorithm that creates the work, so does the invention, there are jurisdictions out there that will not patent protect software or mathematical method per se. So is copyright the answer to actually protecting the AI underlying all of that? And then there's the input. I mean, the reason, or one of the reasons AI is taking off is twofold. First of them is the increase in computation power, but also it's the increase of available data feeding into the AI systems. So what do we do with that new dawn of data? Does the data need protecting? Is copyright the right thing to do the protecting? But copyright impacts all part of AI. For me, is the input that goes into the AI that does its thing, and the output, and really looking at all three areas is going to be absolutely crucial and has a lot of questions attached to it. This is just a whistle-stop tour for those that have not seen the draft issue paper. Here are the big headlines of the questions asked regarding copyright in the issue paper. Unsurprisingly, authorship and ownership is a big one. And really the question there is you can think of it in legislation, and what does the legislation say? And do you need a human author in the legislation, and it should be changed? If you take a step back, really in two very broad stroke buckets, there are two ways of thinking of copyright. One of them is an economic way of saying what's worth copying is worth protecting. The other one is seeing copyright very much as an extension of personality with moral rights. And in having that discussion, depending which view you take on copyright, might give you very different questions and very different answers to that. But a lot of the questions that we have at the moment center around that. Infringement and exceptions, I think everyone's already mentioned it, but again, infringement and exceptions are very different depending which countries you look at, from fair use to private copying exceptions, from data mining, and really what does it mean for copyright and AI if you start tweaking those exceptions internationally. Deepfakes, in everyone's minds, what should copyright do? Should they be accepted from copyright? Copyright or a right per se is another question. The big question of data. Should data be protected? And bias. I think we're going to have a session on bias later, so I'll put that aside. But they're all buckets of questions currently raised in the draft issue paper. And I will finish with a plea for your help. Help us get the questions right. The deadline is February 14th. It's not very long, but if you can help us define those questions, give your views on it. Our commitment is to revise the draft paper and issue the revised paper at the end of March. And then I will look forward to seeing as many of you as possible for the second conversation in Geneva on May 11 and 12. Thank you.
Thank you, Dr. Till. Michelle has the final presentation today on the additional work of WIPO, and I'd like to leave time for one question to the panel. Thank you.
So I
I'm happy to try to be very quick. And first, though, I just want to say how lovely it is to be invited back and to see so many friends here through different phases of my copyright career, including that continuing now. And also to be on this panel with distinguished women leaders in copyright. I'm not sure if Francis is aware, but his office told me to make sure the Copyright Office complies with the requirements of his policy on gender equality, and particularly on the role of women. And I was able to say, Copyright Office, copyright in DC, no problem. So it's great to be here with this distinguished panel. So a lot's been said already. I'm going to be very quick here and just point out another side to the work at WIPO with respect to artificial intelligence. And that is that while asking all these questions about policy and working with all of you and asking you for comments so that we define the important questions, we are also working with AI ourselves to come up with useful systems and tools that can be used both to enhance the functions and processes at WIPO, but also to be shared with international organizations, with IP offices, including copyright offices. And that work is very active. There are a number of very interesting and useful tools now, and the development is really continuing at a fast pace. We have the Advanced Technology Application Center taking the lead on this. I'm just going to mention what some of the areas are. This isn't my area of specialty, and in any case, we have other copyright-specific issues to talk about, but I did want to note that we have, for example, the WIPO Translate cutting-edge translation tool for documents. Right now it's mainly being used in patents, but it extends language coverage. This is a very important area for patent examination, as many of you, I'm sure, would be aware. And so this machine translation tool is really cutting edge and is being shared not only with other international organizations, but with IP offices around the world. Then we have a global brands database. This uses image search, or is an image search service within the global brand database. This allows trademark owners to identify visually similar trademarks and other brand information using AI tools. Also, another technology that's being shared. Classification, automatic patent classification. This is a little different, but is also providing this information in order to help patent filers and examiners examine patent applications. And indexing tools for patent area once again. So as you can see, the area is really very active. There's a new tool that's been announced. Oh, got ahead of myself there. Which is a new digital system for WIPO meeting records. And this, instead of text-to-speech, is speech-to-text technology. And our AI colleagues have been using our AI tools to build this system. The hope is that instead of having resource-intensive verbatim reports, and those of you who've been to our meetings have seen those reports, very thick, very labor-intensive to prepare, we'll be able to have automatically generated and translated speech-to-text transcripts of our meetings in all 6 UN languages using these tools. That'll be complemented by an audiovisual system to provide digitally indexed and searchable conference records. This is a project very dear to my heart, as in my position I have to oversee the preparation of these reports for the Copyright Committee, the SCCR, and this takes a huge amount of time, big budget implication, and would be great if we had this. I was very unhappy with the colleagues when they announced this on my birthday, and my committee was not in the pilot. But I'm very hopeful that in another year or so, we will also be taking advantage. And in fact, we're allowed to use the tool in parallel with our current system, which is very, very interesting and useful in terms of seeing how it works and how we might use it in the future. Very quickly, we're working at WIPO with IP offices in a number of different areas. A lot of them have been mentioned. I'll just note that, for example, one way AI can be useful and is being experimented with in a number of offices is help desk services, automatic replies to clients. This can be very useful for copyright offices. Machine translation, linguistic tools and terminology, data analysis. There's a lot of potential here. I know we'll be hearing more from some of you about how some of these tools are being used either in your offices or in your industries. I wanted to just finish with a little bit of a snapshot and one that's dear to my heart and those of you who worked on the Marrakesh Treaty, and that is in the area of accessibility and the potential for AI. So I'm sure many of you know that at WIPO, we have the Accessible Books Consortium, the ABC, and it operates the Global Book Service. There are almost 500,000 works in the catalog now that are available for sharing across borders through the Marrakesh Treaty. And another big function of the ABC is capacity building, helping countries, particularly developing countries, to prepare materials, usually educational materials, in local languages in accessible formats. One of the big issues that has arisen in a lot of educational materials is using images or making images accessible. And up to now, that's been a very labor-intensive and usually human-intensive work, but there's a lot of research going on now on image captioning using computer vision. So this is a technology that the ABC is looking at very carefully and could be very useful in a broad sense for accessibility, something we're very excited about. It's not entirely ready yet. When you have a possibility that the computer still says that people are various types of animals, you can imagine that that could lead to a lot of problematic situations, and we wouldn't want to put the persons using the tools into a situation where they're commenting as if the people in photos are animals and creating problems for them. So it's not ready yet, but there's a lot of really exciting work going on. A lot of it's being driven by companies with social media platforms to increase inclusiveness of those platforms, so users don't just skip over images and photographs, for example, but are able to engage with those materials. There are, of course, a lot of economic implications that are not related directly just to accessibility, but the lens we're looking at this from right now, accessibility is one where this is very important. It also provides a case study of quite a few of the data and ethics issues that are being looked at in the WIPO AI conversation. So the machines need to be trained with large sets of images for machine learning. Are those copyrighted images? If we say, well, we should only use images that aren't in copyright, does that lead to questions of bias? Does that inadvertently lead to unrepresentative data? There are privacy concerns with respect to the data sets and also the use of the tools. There are liability concerns. If there is a mistake, a problem, and it leads to some kind of situation that generates liability, who's responsible for that? All of these are very important questions, but nevertheless, the exciting thing here is that AI also offers tools that will help us to deliver on the promise of trying to, in this case, provide accessible format works, published works, but that also could have much broader implications for accessibility, for inclusiveness. So this is another area where we're very excited about this work and happy to partner with all of you. Thank you.
Thank you very much, Michelle. That leaves us time for a question I'd like to throw out to the panel, and also for perhaps later discussion in other panels. And it's this. It seems like much of the discussion we have with respect to what is the policy, and we all agree, I think, on the importance of trying to get to the understanding level that Roz talked about. But it seems like it focuses on two aspects. One is the promise of the technology to address large societal problems, or it could be the threat that's going to be caused by unregulated or undefined problems. So how do we as policymakers and participants in the copyright community address this seeming polarization in both promise and threat? And then another question, should you choose to accept it, is, I'd like to follow what Director General mentioned, is the role of competition. How can licensing play here in the copyright community, both for creation and for use? Pick one, both, or anything you'd like to say. We'll just go down the line, maybe starting with Roz.
Oh, okay. I think every new technology brings promises and threats, and I think that where we need to get to is to have a very good understanding of what those are. And I think even from the conversation we've had this morning, we know that there's not even a clear definition of what artificial intelligence is. So we need to get to a point where we understand both sides to find some kind of balance. And I think that's where we always try to end it with a balance.
So, well, tough to say anything after, yes, of course, we always want a balance, and obviously agree with that. And so, I don't think that I want to talk in terms of threats, but in terms of making sure that we look at all the opportunities. So I mentioned accessibility and inclusiveness. Let's not leave that behind in what I think are right now mainly commercial developments. And that's fine, that's a good thing. And usually thrown off from that can be some very good developments in other areas as well. But keeping in mind social inclusiveness, whether that's developing countries or individuals who have a need, there's a huge opportunity here for this technology. And I'd also say, let's be careful not to get so worried about the threats, the liability, the definitional issues, the competition concerns, that we don't fully explore the opportunities that AI brings.
From my view, a lot of the answer is what we're doing here, is engaging with the topic. I think we all know that we don't have the answers. I think the only wrong thing to do would be not to ask the questions. So I think for me the balance is, while the conversation might not be clear and while we wish we'd have the answers to it, actually feeling that uncertainty but having the discussion will go a long way there.
No, I agree, and I thank you all for your contributions today and for not only answering the question, but asking the many questions. And we look forward to continuing this conversation, and as we welcome everyone to participate in the WIPO survey. And I really appreciate, Dr. Tillis, your statement that the copyright seems to be, not at the center, but throughout the entire discussion of AI. And I think that's really important for everyone in the intellectual property community to understand writ large. So thank you, everybody. I think we're going to be taking a short break. Thank you so much.